you very much. As mentioned, I'm Maureen Carlton. I am the Township Solicitor. We were invited this evening to review with you the ordinance and details about that. So as you saw, we have a PowerPoint presentation that Sarah was very integral in preparing. Sarah is an associate at Carlton and Hefner and worked on the ordinance itself and worked on the PowerPoint this evening. So she actually will be in tandem presenting this evening. I'll let Sarah introduce herself.
Thank you very much. Is that close enough? Okay, thank you. I'm Sarah Steers. As Maureen mentioned, I'm an associate at Carlton and Hefner. Very happy to be here this evening. As we go through this, I hope that it is more of a discussion rather than just a point blank in your face presentation. So, I welcome feedback, just making this a dialogue rather than just a boring click through. So whatever you have, hit me.
Great. Okay, thank you. I think as a premise, as mentioned, really was just an ask to attend this evening, just to, I guess, go through the ordinance. And as Sarah mentioned, we'd like this to be not necessarily a presentation, but more of a dialogue with the presentation of the PowerPoint being the basis. I'd like also to mention the fact that I know that this may have been precipitated by the recent complaint that was filed and then the disposition of it within this committee. We'd like to not discuss that this evening, just because there has been no adjudication of that matter as far as we have been advised. So really don't want to talk specifics about that or in particular, but really keep this more as a not necessarily high level, but more of a global discussion of the ordinance and this committee or this commission. Jurisdiction or absolutely. Sure. And hopefully some of our slides, et cetera, will shed some light on that. Okay, so we can start. And yes, we'll just tell you when to move ahead. So the first slide obviously is just a table of contents, and it will we'll go into detail into each portion of that. The first slide may answer some of your questions. It's what the Pennsylvania HRC or HRC versus Township's HRC are permitted and not permitted to do. And Sarah, you can lead this, jump in, whatever. These are the enforcement mechanisms, the parameters, the details of what each are permitted to do.
Yeah, absolutely. Local municipal HRCs are modeled very closely on the Pennsylvania HRC. Obviously, the Enabling Act, the Human Relations, the Enabling Act makes them very similar. But there are some key differences, and we just wanted to put that out there for you. The Pennsylvania Human Relations Act is under the purview of the Pennsylvania HRC, as well as the Pennsylvania Fair Education Opportunities Act. I do not believe that the way that the act is written, that Pennsylvania Fair Education Opportunities Act can be enforced by a local municipal HRC. So that is one key difference right off the bat. that is an authority that has been delegated to the Pennsylvania HRC that would not be extended to the Lower Makefield Township HRC. From there, it's pretty obvious the Pennsylvania HRC serves the entire Commonwealth. It's not just its own HRC, but it also maintains independent task forces, multiple different types of advisory councils. It obviously does case investigation, so it has specifically dedicated investigators who handle the complaints that come into the HRC. And it also has significant training and outreach programs. It maintains offices in Pittsburgh, Harrisburg, and Philadelphia, with most of the administrative duties being handled in Harrisburg. So again, key difference being Lower Makefield Township only handles Lower Makefield Township. I mean, it's pretty obvious, but we have to put that out there. The Pennsylvania HRC is permitted to cover a wider variety of different types of claims. The universes of claims it can touch include employment, housing, commercial property, public accommodations, and education. While the Lower Makefield Township HRC can cover some education issues, it's certainly not as extensive as what the Commonwealth can touch. And then individual protected classes include race or color, sex, including pregnancy, sexual orientation, gender identity and expression, age, specifically age 40 or over, an older age discrimination situation, religion, national origin, ancestry, disability, familial status, and certain types of retaliation encompassed within those purviews. You'll see when you click the slide and we go into what the Lower Makefield Township HRC can touch, the key differences are in your protected classes. The Human Relations Act actually gives the authority to municipal HRCs to give additional protected classes above and beyond what's delegated to the Pennsylvania HRC. And Lower Makefield Township, when it crafted its ordinance, gave additional protections to different types of individuals and different types of people. So you actually can hear more types of complaints than what is specifically limited to the Pennsylvania HRC. So Pennsylvania HRC might be able to hear more education, but here in Lower Makefield Township, you can actually hear complaints alleging discrimination on the basis of genetic information, of marital status, veteran status, and further delineating with persons with disabilities or handicapped persons, the mechanical aids that they use, such as wheelchairs, walkers, canes.
Any questions so far? Yeah,
Yeah.
thank you.
would have provided this case that was clear. Twice, yeah, you know, even though the city got ordinance covered that, you know, or protections for employees who are discriminated by this town. Oh my God.
Correct.
Want to take a stop or do you want me to? Yeah.
And there are that another there used to be question of when, whoa, maybe this ordinance was ridiculous. This is definition of hiring. Isn't resolving. Nobody actually disputes that. Ready? Another help. Ready? The maxway trustee. Forward. Landlord appeal, and the other one. It just really wasn't ready. That's not the problem, never should have heard. And usually what's in it, this is not today. But today we're deciding that the tumble heard by one. Well, you know, I think, one, one of the, I, we're not. Normally, the body being asked. I think. I, eating right, so, you know, exercise, you might, you know, and possible. Someone else, that's not the way I live. Like, I, and part of
Right. Right. Yeah, the HRC.
when you ask.
You want to start or do you want me to start? I mean, I think, on its face, the Lower Makefield's HRC ordinance is more expansive, and I think that's what you're getting to. Typically, in the sense that it adds those highlighted terms or those terms that are bolded. So it is more expansive. Using by example, the situation that was just before you, that was conflated with other issues because of the out-of-state nature of it, as well as the number of employees. Number of employees. I think, we've been talking about this a lot. I will say, as an aside, when that complaint came through and we considered whether or not it was something that was ripe for you to hear, the conversation in our office was, wow, this could be one of the first complaints that a local HRC will actually hear, because there are not that many of them at all. it's, and what you're permitted to. Right, right.
Not- HRC and enforce an ordinance that exceeds the scope of the PHRA. That question has not been decided by any appellate court, and certainly not by the highest appellate. So, me, I mean, that's, until there's so then the question from me to us, how does this commission want, how does the board want this? Those seem to be the issues, not what is the law? The law is unsettled.
Right, and we're certainly not going to adjudicate it. We don't have the ability to do that. You're right. In many times, and again, part of the conversation when preparing the ordinance, when drafting the ordinance and preparing for especially this meeting, is the fact that many of the complaints that you may or will receive are going to be I look at this as almost like a mediation or arbitration panel, quite honestly. And that's where that's going to be your purview at this point in time. I think that many of, do they have the right to go to the Pennsylvania Human Relations Commission? Possibly in some instances. Do they have the right to, if the adjudication, I use that word in quotation marks, if the decision rendered by this group is not favorable or acceptable to other party, they always have the right to go to the Court of Common Pleas. So really, I look at this as you are the first step. And it is more of I hate to use the word, and we were discussing this, like, kumbaya moment, like everybody comes together and you try to resolve it, and that's what your task is. That's what your job is. I don't know, and I'll rely on John to this because I came in, I guess after conversations of forming this committee had been set. I don't know what the Board of Supervisors dictates are, or what their desires are as far as not necessarily the purview, but the outcome of this commission should be. I don't know what the board would like you to do other than what I just described. Be the first line of sort of defense or offense to complainants within the township.
I would just like to add, I don't think, I think it's obviously correct to highlight the tension between the parameters of the Human Relations Act and then what's included in the ordinance. But I also think, as you alluded to, this then becomes what is the township's appetite for not necessarily a confrontation, but for how we want to interpret our ordinance and enforce our ordinance. So in terms of, as Maureen said, when this situation came internally to, brought to our attention at Curtin and Hefner, and there was an all hands on deck discussion, we can offer one interpretation for how the LMT HRC should move forward. But then also you internally as an HRC have to wrestle with other constituent board, a myriad of other concerns in terms of how you want to be a public facing commission for the township.
So in terms of background and history and Board of Supervisors review of this, this issue was before the board many years ago. There were some that were concerned that they didn't view that there was an issue. And at that time, by the way, they had not changed the regulations to allow for LGBTQ folks to be in protected classes. That occurred in 2023, I think. So that was an issue. I can say personally, I had received a complaint from a person who worked for a Lower Makefield company. I worked in Lower Makefield. I don't know where the company is headquartered, although I think in Bucks County. And so I thought, okay, we needed to do that. The board perspective about your enforcement, I can't speak to and give you a direct answer that says, they want you to be restricted or limited, because I don't know that that's the case. And I also think that opinion may evolve with board composition. And so I would suggest that you can independently, again, and this is part of the deal. I'm a liaison. I'm not a voting member. I'm not a decider. You are, right? You can make those determinations as a commission to say, hey, we want to take a more aggressive approach to engagement. The question becomes, if there's a circumstance, let me use hypotheticals here. The case that if it were a case involving an out-of-state corporation, does the Pennsylvania HRC have purview over that? If they don't have, what's the purview of the companies outside of Pennsylvania?
There are some parameters, I mean, they have to fit certain criteria, whether or not, but generally speaking, no, would be the situs or the place of where the employer is based. There are lots of tentacles that expand from that they could have
Right.
had jurisdiction in certain instances, but for the most times, it is the location or locale of where the business is located.
So I think there should be some concern with the change in the structure of how work goes, where more and more folks work remote and are not protected in theory under the Pennsylvania HRC. We have a number of LMT residents who work remote for corporations all around the world, including me too, right? Although technically I used to have an office in New York, but I don't anymore. So that's an issue. In theory, none of those claims could be, because if the company doesn't have an office, right, it may not hit that. So there's a whole host of folks that aren't currently served by the Pennsylvania HRC, whether it's a status issue or employer issue. And the question becomes for the commission, do they wish to engage in those cases? And I think you're suggesting that, or at least the combination of you are suggesting that this is not settled law, right? And that there's a balance between being more aggressive in enforcing versus perceived potential litigation risk down the road. Is that where you're coming from? I'm sorry to kind of position a question back to you that way, but do you think I'm not sure that we have significant litigation risk if we go to help mediate these circumstances, right?
True. That's
Okay.
correct. Yes. And that's how again, not speaking for the board, I don't know if
Right.
that's the position that they want you to be in the position of, as to be the sort of mediators, arbitrators of, and hopefully it is settled and everybody just goes home happy. Or if someone is unhappy, then there's always the court of common pleas as the entrance or exit out of that conversation or
Right.
discussion.
And this is where I think, again, this is a commission decision separate from us. They would determine the process under the ordinance as to how they will process potential claims, right? And then the question is, they could choose the parameter as to where they would potentially go forth and enter into mediation or discussion, or where they would say they don't have jurisdiction, right? That would be a commission decision, not anyone else decision.
Within the confines of the ordinance, correct?
Yeah, okay.
Yes.
So I gave you a long run answer that is ponderous, but I don't think there's anything that stops you from making the decision however you see fit collectively as the commission separate from the board, right? Unless we perceived a risk and we were to tell you directly, which we're not yet perceiving.
True, but they work at the pleasure of the board.
That's true
Correct.
as well. Yes.
And that's.
Yeah.
Right, and I guess as the state courts have not adjudicated this or made final decisions, they keep pushing it around or pushing it back. 1998 case that hasn't been really resolved or yeah, adjudicated with a final order. I- The Board of Supervisors is sort of in the same boat. You know, I guess it's one of those things when a situation arises that they will have to have input on, they will. But to that extent, they will let you work and do what you think is the best way to approach a situation with input from us if so needed, by way of example, the last matter. But again, I believe that, again, not speaking for the board, but I believe that they thought because of the reasons why this was set up were the reasons John enunciated. And I believe that they believe that this is really the first line of conversation, first line of defense for township residents. That makes sense? No?
They're really just the first line of defense. We really want you to go somewhere, somewhere else, and you don't know that. Now, in this case, as a matter of policy, they did go, I think, to the certainly better equipped than us to handle matters and kind of on the bottom line as a policy matter. And us. Well, you
Go to the PHR.
Really good.
Correct.
But there are people. One that have they are employed by companies which do them. They have no other choice. In the out of state scenario, and the law is that here, regardless of where they're headquartered, it employs individuals in the state of Texas subject to the state. In the new world, with remote employees, here's the problem. You can have a New York employer, an Illinois employer, and two we subject to live in all these any Texas. The Illinois statute might not provide any protection. Now you have a township that's nothing to work. We're still asking them like, oh, where did the employee? They wanted to work PHRA by the goal situation in less than as our ordinance. And the employee in lower Makefield Township. How do you know that, by the way? You can help them do it. That's how you know. If they're working out of Princeton, that shows up on their document. But so in that rare, and frankly, different. I mean, really learn about it. Rare situation. We were in bold. We're the only place they can. Oh, by the way, it's not clear whether the Enabling Act was defeated when we passed the ordinance, so we're going to let it off. To the member statute.
Not until September. Very happy until September of next year.
At, at a certain point, I'm sure that this discussion had to have happened when the overarching enabling act, the HRA, was being written, because they would not have specified in the act, local municipalities have the right to draft their ordinances with more categories than what we have been delineated as a Pennsylvania HRC. So at a certain point, that must have been a discussion that must have been contemplated. But again, our analysis as solicitor would be different than the appetite of the LMT HRC.
Yeah.
Or doesn't like how we're doing it, they're gonna tell us.
They'll let you know.
Fair.
Correct.
That's essentially what we.
Right.
I mean, I guess that's
Yeah.
the distillation of local politics to a certain extent, but
Yeah.
yeah, absolutely. I don't disagree with that sentiment at all.
And again, I think if we get through the slide presentation, and I don't, I mean that in a very positive way, because this is a great conversation, is the fact that, you know, you have to look at what your authority is as well. What remedies are you permitted to distill on a complainant or a respondent? Not many. You know, I mean, you have authority, but you don't have, you can't fine them, you can't take away property, you can't, it's a public reprimand for them for all intents and purposes. So you have to look at it that way. And simultaneous to any complaint that a complainant can or may make to you, they have the ability to go into our court system and do the same thing. And the real teeth are with the court system, not with necessarily this commission as well. I think it serves a purpose for those reasons enunciated by John earlier. Absolutely. And I believe that's why the supervisors were willing to go to the steps of passing the ordinance and setting up the commission. But at the end of the day, I have to look at what your real authority is with respect to those that come before you.
Would say though, in the questions of authority and or justice, in some cases, the fact that you can't take property or money from somebody isn't necessarily an indication that justice isn't being served. In that, if you have a finding that says, you okay? Oh, sorry. In the matter of, the HRC finds that X corporation violated X, Y, and Z, even though you might not have the ability to enforce a penalty on that company, that becomes a public record, which becomes searchable. And if coming from a .gov domain has very high, although search engine results are changing with AI, but is an indicator so that when people go to make an inquiry about a company, they will find those kinds of things. And they will make that part of their assessment if they want to work for that company.
So I'm sorry.
Do the right thing.
Right, yeah.
Because
you should do the right thing. Like, and it's just sort of like, as you said, it's the kumbaya, like, it's mediation, it's not right.
I said at the beginning, right?
So I think we're not reading our ordinance the way potential plaintiffs or their lawyers or employers would read it. So this ordinance provides for all sorts of financial penalties to be assessed in court
Right,
after and only after we hear it.
right.
So we are the administrative remedy that has to be exhausted before someone who has been harmed grievously is allowed to go to court and recover on our ordinance. So yes, we can have a kumbaya moment, we can try and work things out. But at the end of the day, an aggrieved person, which is the ordinance language, has to come to us. And if we don't have to find in their favor. We can find against them, we could find for them. You're right, we can't impose damages, but unless and until we do, they can't go to court. And that's section, yeah, of course, it's 12-7. That's the private right of action, and 1 and 2. And this is, I mean, I'm a practitioner. This is what I'm looking at when someone comes to me and says, I was discriminated against in Lower Makefield Township. Okay, well, you can go to court and you can get back pay and damages and injunctive relief in court.
If you, this as a requirement to come to us.
Well, that's
Well, what?
the next section. Yeah. This,
And then,
our local ordinance has teeth, and the teeth are damages which can be assessed in court, but you can't go to court until you have come to us. That's 12-7-2, and that's not unusual. Every single discrimination statute I know, except New Jersey's, requires exhaustion, including ours. So to deny someone access to us is to deny them access to court and to damages which our ordinance provides for. Though you're right, the most we can ever do is make a finding or a non-finding. But we potentially do harm if we say we're not going to hear you. Now, sometimes we have to, because it may not be covered, right? They may be not an employee at all. For instance, it could be an independent contractor, not covered. But that's why I'm vociferous about us. If we're going to have this ordinance, we should enforce it as written, and unless and until the board tells us not to, in which case I agree with Tara, amend the ordinance. While I'm on this board, or any other commission, I should say, I'm going to enforce the ordinance that authorized me to do it.
I don't know if I necessarily agree, because look at 12-7, number 3.
Right.
Nothing in this subpart limits the right of an aggrieved person to recover under any other applicable law or legal theory.
Under any other applicable law. So for instance, the PHRC, you could file with the PHRC, but we're talking about the situation where someone hasn't.
Yeah.
You could bring a wrongful discharge claim under common law in the Bucks County Common. What you can't do is bring an action under this ordinance without coming to us first. That's what this says. If you're pursuing a claim under this ordinance, which provides for all these damages in 12-7-1 A through E, then you must come to us first. That's what 12-7-2 says, and that's exactly what the PHRC says. And incidentally, that's why it's important that we have an ordinance that has timing issues, which we talked all about last time, so that you can properly exhaust, which means you got to come to us within 180 days. It's 182 days. Oh, well, we don't have power. Sorry. So anyway, I agree with you that we can do the best work. If anyone ever comes to us, we could do the best work trying to create agreement and compromise between employers and employees, landlords and tenants. But that's not always the situation. Sometimes you get that call, that person shows up and the harm's already been done. So,
Or non-cooperating parties, et cetera, absolutely.
yeah, not everyone, not, sometimes one side's unreasonable, as you know, sometimes both are unreasonable.
Correct. No, this is
Honestly, we're here to engage in this dialogue, answer these questions, poke holes in the ordinance, see where things may need to be refined. Bring this up however you as the HRC sees questions and concerns.
and make suggestions to us to bring back to the board to amend the ordinance. Absolutely. Again, this is all, this is all first blush. This is new
Yeah, absolutely.
to everybody, to you, to the board, to,
Are there other sort of pertinent things? I don't want to cut you off from a larger discussion. I know you probably have a lot
I think
more
we've-
in here than.
I think we've beaten this one as much,
but it's an important part of the discussion because does it mean that the conversation or this continues? But I think we should continue. And again, we can go back and revisit and, again, you can come to us with ideas that we would evaluate ourselves and then go to the Board of Supervisors where we think there are holes, where there are misses, where things have to be amended or changed, or where you would suggest.
I think the only real takeaway from this particular slide that hasn't been discussed in our previous, engagement is simply that one does not have to be a constituent over a resident of Lower Makefield Township to avail themselves of this ordinance. You can live in Lower Makefield Township, but you can also work in Lower Makefield Township, or even quite frankly, simply be a visitor to Lower Makefield Township. Say if you, went to a local retailer here and felt that you were discriminated against under the umbrella of this ordinance, that would also qualify you to avail yourself of the protections of this ordinance. In that sense, it's quite an umbrella ordinance. Specifically in terms of the Lower Makefield Township's HRC, these big areas that you protect are employment, housing and public accommodations, and acts, and specifically because we did touch on this very early, the limiting factors for you to touch on education situations. Yours would be access to post-secondary educational institutions. So for that, that's kind of distilled into the opportunity for a person to have equal access to a post-secondary education for which the person is qualified, and that includes admission, access to scholarships, and even school resources. So it might not go as into it as other specific education statutes at the federal or Commonwealth level, but that's the limit on your purview of education discrimination within the world of education.
Which is not as expansive as Pennsylvania HRC, as we mentioned, really at the top of the conversation.
When we get to the protected classes, most of them are pretty obvious on their face. There are a few that, I just wanted to pull out and give kind of additional perspective onto what you would be looking at if someone came to you with that kind of claim. Under religion, it would not only be alleged discrimination for religious beliefs and practices, but it would also be the lack of religious beliefs and practices. For ancestry, it's the getting more general, I know we all colloquially know what that is, but under the umbrella of your ordinance, it's the nationality or ethnic group from which the person is descended, national origin country from which in which a person had been born, and sexual orientation. I know that we hear a lot about this, but it's not just your actual sexuality, it would also be your perceived sexuality. So you may not fall under a specific type of sexuality, but if you believe you were discriminated against because someone even thought you were something else, that's enough to trigger this.
Does that include an individual's expression and their own perception of their sexuality rather than someone else's? In other words, they perceive, if I have a self-perception
Right,
of myself as a woman
right.
and someone else interprets me
So
to
it,
be something other.
yeah, I think that would not only fall under sexuality, but that would also fall under gender identity and expression. Right. Correct. Yeah. But to the extent that that perhaps perceived discrimination would trigger both, then I believe the complainant's complaint would have to indicate both. Not necessarily have to, but it would behoove them to be as expansive as possible when explaining the perceived discrimination. And now moving into the gender identity or expression, this one's a long one. I do have this, I can email this to all of you guys tomorrow. We might not need me to read this one out loud, but I think it further goes into this perception of gender identity and expression. From there, familial status, that can be not only an individual who lives with a parent, but it's also a person having legal custody or any person who is pregnant or in the process of securing custody of an individual who's not yet 18 years of age. I don't know if I don't believe your ordinance goes so far as to specifically and explicitly state pregnancy in the same way that the Pennsylvania Human Relations Commission lists pregnancy as an individualized protected class. Again, as we're having this conversation about, would our ordinance have more teeth? Would our ordinance be able to be enforced if certain protected classes were enumerated or listed? That might be something to have in the back of your mind.
And I do not believe it does. I believe ours does.
No, I don't believe your ordinance explicitly lists pregnancy or being a pregnant person as a protected class, the same way that it is under the overarching statute. So I don't know if that's something in the back of your mind you want to think of as an individualized call out, so that it's specified in a way that it's not implied.
I was going to say on the familial status, that's important for housing discrimination because we have municipalities in Pennsylvania have passed blatantly unconstitutional ordinances say that no more than two unrelated people can live together. And they do that for a lot of different reasons. There's actually a Supreme Court case, Moore versus East Cleveland, that prohibits such ordinances, but sometimes Supreme Court decisions don't filter down to local ordinances in the same way, which is why those kinds of things need to be in here as well for those classes.
Many of those ordinances were raised mostly in college towns especially, and that's the reason for them, to limit the ability to have fraternities, sororities, and other things such as that in college towns.
And finally, I would just like to highlight with mental or physical disability, although your ordinance doesn't explicitly state this, this is often interpreted to include persons associated with a person with a disability. So again, as you're thinking, we're not specifically calling this out. This is implied. This is how it's been interpreted in the past. But if you are concerned as an HRC with, do we want this to have specific call outs that there's no questions, that there's no ambiguity, that might be something to have in the back of your mind as well. These are just examples under your main three overarching umbrellas. You know, a type of discrimination under your employment umbrella, your practice area umbrella, you know, issues with compensation, quota systems discharge, with housing, evictions, failure to rent, failure to sell, and with education, different terms or conditions for different students or even categories or umbrellas of students, harassment issues, or say if a post-secondary institution refused admission and there was a perceived discrimination or discriminatory intent behind that refused admission. This is kind of a more visual walkthrough of what the process of your ordinance explains. I don't know if you really need us to go through this, especially as you said, you discussed the process at length in a prior meeting. But to the extent that it's a visual representation, kind of arrows and feeders as to what your actual complaint process looks like, starting with the inquiry, which is not required, but is something that you include on your website as a supplement to your ordinance, that someone can, describe it to you and see if there's even validity to moving forward with a formal complaint. And then it walks through the different aspects of all the way through to the, I think, what do you call them? And my apologies. You call them your expanded procedures. So I don't know if you want me to walk through that tonight. It sounds like you've had this discussion previously. But if you like things represented with green bullet points and arrows, you've got that at your, to review at your leisure.
Will you share the PowerPoint with us?
Oh, absolutely.
Okay.
Green bullet and bullet points, but it's similar because we were trying to figure out what are the time and the importance of time on speak on.
Right.
And they are very important for the reasons that we just talked about, because if there is going to be a complaint within the court system, statute of limitations are always apply.
There's a number of those slides. I don't know if you just want to click through them. The header will change.
Oh, what she was trying to do.
No, I'm glad. That's nice to hear.
And this is what you were describing earlier.
Correct.
Right.
And that bottom one, expanded procedures, if a complainant does request expanded procedures, or if in front of an en-banc meeting of this commission, you decide that expanded procedures are warranted, then the next few slides also contemplate your expanded procedures.
Very, very. Stop me if you want me to stop something.
I think you can just click through. And here, to the extent that this is a concern for this commission, we did touch on, as you mentioned, you hit 182 days. Sorry, that's where we end. We have a 180 days. But it's written into that, like, obviously, calendar days can be fickle, so you get a little bit of wiggle room if you're on a weekend or a holiday. Complainant can always withdraw their complaint. That's never a problem. If at any point they say, you know what, I still need more time to get my emails in a row, figure out, like, I can't find that one email from last August where he, called me a name. I'm going to withdraw this until I can get you my smoking gun. They can always withdraw their complaint at any time and then reinitiate that complaint. But that 180-day window, my goodness, my apologies, still remains. And then it is subject to this phrase called equitable tolling. Long and the short of it, I put the fancy legal definition there, but I mean, the long and the short of it, and Maureen, correct me if I'm not stating this eloquently enough, but it's, if you know it's there, but you just haven't been able to find it and you're still looking for it, we're going to give you the benefit of the doubt, and maybe you get a little bit longer than that 180 days.
Stops the clock.
Yeah.
Is probably the best way to put it.
And then, to the extent that if the perceived discrimination implicates any other types of Commonwealth or federal statutes, as an example, if you were to file a complaint with the federal EEOC, you have 300 days. If you wanted to file a housing complaint with HUD, you have 365 days. This is why I definitely want to get you this in PowerPoint format. A couple of these links take you to really interesting nonprofits. I tried to be judicious in finding additional resources. I didn't take you to any weird .coms. I'm sure that everyone's familiar with the Pennsylvania HRC website, but they obviously have the largest source of Pennsylvania specific information, particularly their trainings and their other advisory materials. I linked all that for you. There are a couple of really good nonprofits and papers. The first 2 bullet points are those. Not that you are beholden to information that any other township uses as a resource for its HRC. But those two first bullet points are used by other Pennsylvania municipalities in the area as education tools with their HRC. I believe it's Upper Dublin and State College. A couple other ones, Montgomery Township uses these, and I want to say Gettysburg, but I think primarily Upper Dublin and State College rely on those links heavily on their website and really encourage their HRC members not only to review them, but people initiating complaints with their relative HRCs to review them. I thought they looked like really good resources provided by, you know, really reputable organizations. So I wanted to include them for your education as well.
Thank you so much. Both of you. It's a lot of work to put this together and maybe even more to try to work through how this group is thinking about things, and we really appreciate the time and your, your expertise.
No, well, it's lovely to work with folks that have an expansive mindset. So we're really here, you know, to provide a service for you, whatever questions you have. We want to be able to come back to you, you know, with responses that are couched in the appropriate legal language.
Maybe not necessarily answers, but at least continue the conversation.
Absolutely. Anybody have a question for Brenda?
I have a request. If you come upon, so the primary place these local ordinances are going to go after the HRC is to a state court. And of course, those decisions are rarely reported in any way, shape, or form. So we really don't know whether there have been 2 or 2,000 of these cases throughout the state that have actually gone to the state court. I don't know of a resource to find out about it, but if anything comes to your attention where we could get a kind of a handle on whether any of these things are actually getting processed through local ordinances as opposed to Title VII or the PHRA,
Right.
would you let us know?
Yeah.
Yeah, we can do some research on that.
Yeah, most of the, anecdotal responses I've gotten to folks that are on other commissions is no one ever files a complaint. So, which is not surprising. There are lots of other places to file if you work for an employer that isn't really small. But if anything comes to your attention, I'm sure we'd like to hear about it.
Absolutely. Yeah. And again, I think that sort of summarizes it. I think I started at the beginning when faced with the complaint that you were presented with. Again, the conversation in our office was, wow, you're going to be the first. You know, Lower Makefield could be the first. Turned
I
out
don't-
before, But
I don't believe, I can't imagine that, but maybe, I don't know otherwise.
I mean, we represent a lot of,
Yeah.
many municipalities. It
Yeah.
was just within, the scope of who we represent and the contacts that we have. But let's
Well-
just put it's a rarity.
The Rydell case, that was filed.
Mhm.
So that was Reading. This was the Reading, and then it was housing. So, my background is employment and not housing or really education. So there's that whole other aspect that, could, be more likely to get to court even under the same, ordinances. So there could be some law out there that it's trial court level. That's all. But
Oh, sure. I'm not saying that there aren't any, but they're few and far between. Let's put it that way.
okay,
Thank you.
thank you.
all. Thanks.
Um, No, of course
No.
not. No, he definitely said Thanksgiving Eve and Christmas time is terrible.
Yeah, so and this doesn't have to be something that we choose now. You do all have access to the meeting calendar. Actually, I take that back. Katie sent me the updated one today. So Tara has access to it because this has been an ongoing thing with all the committees. It's like trying to herd cats, trying to get everybody in when they can and when there's availability with the room. And there's only so many limited times after hours. So like from 5 to 7 or 5:30 to 7 or 6 to 7. So there's limited time slots. I have the updated calendar in front of me. Tara, if you want to send it out to everybody, or I can send it out tonight before I leave. Just at a glance, there's a Monday available that I see. Monday, December 1st as well is available, but I remember all the struggles that we had early on trying to schedule. And I know that I don't think Mondays worked for anybody. Maybe that's changed since it's been about a year.
You're welcome to like still have a conflict down there.
Yeah.
Yes.
Perfect.
Let's do December first.
Okay.
We'll look at our timeline and so if we need to do like a short one, we'll wrap our heads around the discussion today, so it's gonna be brief and then.
Yep.
And everyone should bring holiday goodies.
This is shocking to me, actually, that nobody picked that day. I'm gonna talk to her tomorrow, make sure there's not some random something going on here in the room that we can't have. We can do 6:30. Yeah, the whole night is open. That's the Monday after Thanksgiving, so maybe, I don't know, people are gonna be away. Maybe other committees didn't want to pick that day. So I will just 100% confirm with her tomorrow, and if so, we'll be December 1st at 6:30. Yeah. Yeah, so you'll have that in writing tomorrow at the latest.
Second.
Hey, he's a voting member tonight in the absence of our Vice President Kathy. You do. Who seconded that, Byron?
I second.
Oh, Stan. Thank you. Have a good night.
All right, good luck with the college. Next time I want to hear some progress.